Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legallistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. Hey, welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy. The Queen and Vidinovski, heard in writing on July 2nd, 2020, an appeal from the convictions entered on June 26, 2018, by Justice Alfred O'Mara of the Superior Court of Justice sitting with a jury. Following a trial before Justice O'Mara sitting with a jury, the appellant was convicted of 3 charges of fraud over $5,000 and 4 charges of uttering forged documents. She received a sentence of 18 months custody followed by probation. The appellant appeals the conviction. The complainant, Linda Sargent, owned a real estate brokerage, Core Realty Group, Inc. In 2011, Ms. Sargent hired the appellant as a general office worker. The appellant impressed her employer and was soon given increased duties. Before long, the appellant's duties included many of the financial functions of the office. She managed the accounting and trade record system, created employee paychecks, paid bills, and managed deposits into the company's various bank accounts. In October 2014, Ms. Sargent decided to terminate the appellant. At about the same time, she became suspicious of the appellant's management of some of her financial duties. After her own investigation, the police became involved and the appellant was charged. The appellant was convicted of defrauding the business in 3 ways: by generating additional payroll checks and forging Ms. Sargent's signature on them, then depositing the money into 2 personal accounts; by forging letters of direction on the company's letterhead authorizing the company's bank to provide her with money orders made out to the Metcalf Living Management, her landlord; and by creating and depositing checks again with a forged signature, labeled as petty cash, but drawn from the general account. The appellant advances 3 grounds of appeal. First, the appellant contends that the trial judge erred by failing to grant a mistrial application made by her trial counsel in response to extremely inflammatory comments by the complainant during re-examination. The impugned comments occurred in this exchange during the re-examination of the complainant. Question: Ms. Sargent, you were asked some questions in cross-examination about whether you had made romantic advances towards Ms. Vidinovski. And I saw, and again now you're smiling, and you smiled when you answered some of those questions. Can you just explain why you're smiling? Answer: well, for many reasons. It makes me emotional because it's very hurtful. I'm in a very loving relationship that I honor. I was nothing but fair to Susanna. And I think that everybody has a son, everybody has a daughter, everybody has a friend. And I think to pull the gay card for an excuse for very bad invasive behavior, I don't publicize my life for people. I think that it's just a dreadful out there for people to do that. And here we are today. We're decent people and we're the Me Too environment. And I think that things like being thrown around so frivolously in a courtroom when someone is alleged to have done this type of thing to me is absolutely abhorrent. On behalf to a young lawyer, think that I should go to the validity of the case and what's before the courts and people like you versus that sort of attack with someone like me. It's visceral. And people can search this on the internet if they want. Yeah, it's abhorrent. I set precedents in Canadian law for bad behavior with a company about poisonous work environment and sexual harassment, and I would be the last person to tolerate that in my office. It's abhorrent. Shortly after, defense counsel asked the trial judge to instruct the jury about this alleged attack. After the lunch break, defense counsel asked for a mistrial. He said that these comments tainted his client's defense because the complainant had accused him of using the, quote, gay card. On appeal, the appellant contends that the trial judge erred by not declaring a mistrial. We don't accept this submission. The trial judge carefully questioned defense counsel and then gave this mid-trial instruction to the jury. Quote, ladies and gentlemen, before continuing with the witness who was giving evidence earlier, there are 2 instructions I wish to give you concerning matters raised in re-examination by Ms. Sargent. The other matter is that Ms. Sargent commented about certain counsel raising a certain issue that she, with respect to a suggested romantic interest in the accused, that she found personally abhorrent. Counsel, as defense counsel, is obligated, indeed counsel is duty-bound, to advance vigorously any defense in theory and indeed it is not improper to have done that. In fact, it is expected of defense counsel to do so." End quote. In the Queen and Burke, the Supreme Court of Canada said that a mistrial should only be used to prevent a miscarriage of justice, and at paragraph 75, quote, "The trial judge is the best positioned to assess the circumstances of each individual case and select the most appropriate remedy," end quote. We see no error in how the trial judge handled the mistrial application in this case. Second, the appellant submits that the trial judge erred by dismissing her Corbett application to exclude any reference to her previous criminal record. The appellant had previously been convicted of fraud offenses, but more than 20 years ago. The trial judge decided to allow the jury to know of these previous convictions, but he also provided the jury with a strong caution. In the Queen and R.D., at paragraph 13, this court said that, quote, "Defense is owed a trial judge's determination of a Corbett application," end quote. We see no reason to interfere with the trial judge's analysis and conclusion on the Corbett issue in this case. The defense made credibility of the complainant a central issue at this trial. As explained by the trial judge in his Corbett ruling, quote, "I consider in the balance as well the nature of the defense advanced in this trial, which has been a concerted attack on the credibility of the complainant. Linda Sargent, owner of the realty company alleged to have been defrauded by the applicant. It is alleged that the complainant has fabricated the fraud allegations to prevent the applicant from pursuing a sexual harassment complaint," end quote. In this context, the trial judge was entitled to permit the jury to know about the previous fraud conviction. Importantly, however, the trial judge also reminded the jury that the previous conviction was in 1994, well before the events that gave rise to the current charges. He also emphatically warned the jury that just because the appellant had committed fraud in the past did not mean she was guilty of committing the same offense now. Third, the appellant asserts that the trial judge delivered an unbalanced and unfair jury charge. There is no basis for this claim. The trial judge gave a balanced charge, both quantitatively and qualitatively. In particular, the trial judge highlighted some of the main issues in the appellant's position, especially difficulties in the complainant's testimony. The jury charge was balanced and fair. Although the trial judge did not follow the common and desirable practice of reviewing his proposed jury charge with counsel before delivering it, we cannot say that this cast doubt on this conclusion. The appeal is dismissed.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.